Crickets, Miss Smith was happily dancing away in the jovial mood. Importantly, Mr. Nico could see him, was also present at the event. At one stage, Miss Smith was called onto the stage to receive the blessings, and he recognized her as his own, whose child he is now missing. And he remembered what she told him in August the previous year. He was bothered by this and attempted to inform his wife of it. She had, however, reported that they were simple people. This is too big for them. They shouldn't get involved. With due respect to his spouse, he took time to reflect upon it. It had ever bothered him so much that he was looking for the first opportunity to share what he knew. The following Wednesday, unaware of the events that took place between the 4th and the 5th of March, that Wednesday was now the 6th, was the first day he was working in Jacob's buying for the Kruger's. I also paused to note that he also worked for a person by the name of Shark, Louis Joshlin van Saint, who is a labor but for an open plot to the Krugers. He happens to be the control prosecutor at Vredenburg. So on the morning of the 6th, reporting the issue to the Krugers first, who they called Mr. Van Sail. Mr. Van Sail was already aware of the events of the previous day, and that Miss Smith was implicated in the offences. Whilst we, at the event of the 3rd, and reflecting on Miss Hanif and the dancing of Miss Smith, let us return to the 20th of February, when she was in a video call with Miss Smith. Miss Smith being at Kenzie's residence. I refer to the irritation shown by Miss Smith earlier on upon the inquiries about Mr. Thomas. But at that stage, Miss Smith also told Miss Hanif that the police must do their work and they must stop looking for Joshlin. The terminology used at the time to Miss Hanif was not referring to Joshlin by her name, but rather as the child. I mentioned here as the next topic I shall deal with is the admission of the statements by Mr. Apollos and Mr. Van Rijn. Because what became apparent in those interviews that Joshlin was not called by her name, but rather depicted the child. So let's revisit the trial within a trial, and I shall not dwell on it for a long time. And the reason for that will become obvious. Day after the visit by the minister and the prayer meeting was a massive search in this area, where this venue that I didn't know of before we chose the venue became an operation center. Police officials from all over the province, of all detective branches and all the different sections of SAPS, community members, community organizations, interested people were searching the broader area of Saldanha Bay towards Jacobs Bay, the dunes, the beaches. The Navy was involved, and it became a big operation center. What nobody knew was that Captain Lombard and his team was in the field that day, but led by their commanding officer, Brigadier Nana, who took up position at the sea border offices, sitting in the FCS commander's office. They had already decided that they will have to now re-interview the three individuals, being Mr. Apollos, Mr. Van Rijn, and Ms. Smith, on the same basis of all these discrepancies and the red flags that were raised earlier on that I've discussed, plus the conduct of the individuals in the meantime. So after concluding their work on the search, Mr. Apollos, Mr. Van Rijn, and Smith was brought in by different people to the offices of Seaborder Police, where FCS officers are also situated. Interviews were conducted, and various police officers testified as to what had happened, but more particularly Captain Lombard, Sergeant Fontaine, Sergeant Johnson, as it was alleged that undue influence was exerted on Mr. Apollos and Mr. Van Rijn, and they were viciously tortured. Some demonstrations became laughable, to say the least. The indications on the evidence and what was put to the witnesses were totally different. Plus, I was told that what they had admitted to in those statements came from the police, and the police told them what to say. I have no hesitation in finding that the evidence for the defense on that score was so bad that nobody can believe. No wonder they didn't come and testify again, because the prosecutors wiped the floor with the evidence, to use the colloquial term. On the other hand, there was no reason not to accept the police evidence of the officials that I've mentioned, because over and above the medical examinations and what was told to the doctors by Mr. Apollos and Mr. Van Rijn as to how they sustained certain injuries they had on their body, I was fortunate that a process was followed where these statements were video recorded. It then not only sits with somebody to add on because you can see what's in front of you. One can see the demeanor of the deponent. One can see the conduct of the police official taking the statement. One can see the scene. It doesn't end there. Let me turn to Mr. Apollos briefly. We took time, sentence by sentence, confirming or not confirming, both by counsel on behalf of Mr. Apollos and myself. And then, of course, as we know, what's confirmed when Ms. Smith is not in the courtroom is recanted when she is. To make it worse, I've been told that was in those statements came from the knowledge of the police. But then Mr. Apollos tells me he made up the story as he was sitting in front of Colonel Pretorius. It's prompted me to pose the question where his sudden talents came from. Because there was information in those statements that the police had no knowledge of. Similarly, with Mr. Van Rijn, turned out that, and I've criticized Captain Seagoy about it, that not everything that he said was written down verbatim. If one listens to the audio on the video recording, it's crystal clear what he said. And a lot of those issues were not challenged. It was claimed that he was asleep, or that when he yawned, his brain was malfunctioning. But when he testified, it was a different story. Then he was wide awake. Initially, he was spun like a top around an axle. Then, when it became apparent that it is impossible, then he was just swinging or rocking like a boat. We asked him to illustrate. It was clearly impossible. Initially, it was unclear what type of pole or pipe or structure was used to spin him around. Then it became a crutch. Not only there was a gentleman in court that had a crutch. The least said about it, the better. My finding is that the credibility was so bad, and on the other hand, the state's evidence was of such a nature that I found it to be credible and reliable, and the statements were admitted. Mr. Apollos and Mr. Van Rijn made their statements before they departed, that evening, or early morning, or 5th now, there was the encounter between Mr. Apollos and Miss Smith. Miss Smith did not give a statement then. She gave a statement at a later stage. That became the warning statement. Both of them, at some stage, told the police they must ask Miss Smith. When she was told that they said that, she exploded, asking Mr. Apollos how he could do that to her because she loves him. I'm going to deal in a little bit more detail with Mr. Coetzee and Ms. Lombard. But before I turn to them, it's important that one have regard to the so-called warning statement of Ms. Smith, which was handed in as Exhibit QP. And this is the statement that she wrote in her own hand. If you look at the time that was given there, she returned home at 11:30. She borrowed the money, bought it, went home, and she was back at Carl Ziegler's house at 12:30. Then she eventually went home at 16:45, 4:45. Joshlin was not at home. I contrast that to the previous statement that I've mentioned. The time that she realized that Joshlin was not at home, the latest would have been 5 o'clock. Thereafter, both herself, Mr. Apollos and Mr. Van Rijn, went on their sojourns to get the gas and to go and cook. No concern. That's on the version, insofar as it's a version of Miss Smith. Now let me turn to Mr. Coetzee first. Mr. Coetzee is a single witness as to what had transpired on the August morning of 2023. Ms. Lombard is also a single witness insofar as it relates to what she describes with the white polo. And I'm well aware that the version provided by Mr. Apollos and Mr. Van Rijn as to how Joshlin was delivered differs from hers. So in both the cases, I will have to apply a cautionary rule. I have to find some warranty of reliability for the evidence. When a court considers that, you may also take into account the demeanor of the witness. Mr. Coetzee A made a favorable impression in the manner in which he presented his evidence. He has no motive to put himself in this situation and get into the case. At the time when he reported to the Krugers at Van Sale, he was unaware of the arrest. Where does he get the 20,000 rand from? Because he was never part of any of these other discussions, and it was not out in the public domain either. So, even on the probabilities would favor his evidence. More importantly, there is nothing to gainsay Mr. Woodsey from the defense. And I shall get to in which instances inferences can be drawn from the silence of a person accused. In this instance, it calls out for an answer. Because either he's not only an evangelist but also a prophet. To have known what was going to happen. He says Miss Smith told him that. It's not challenged. In cross-examination is challenged, no other evidence. But it's also supported by the circumstantial evidence around this case. Miss Lombard is a bit different. Because not only is he a single witness on the commission of the crime as she describes it, but she's also a participant. So I've got to treat her as a single witness, it's a caution to you. You've got to deal with her as a participant. I also have to have regard that she gave different versions as time went on. When Constable Sikhovic, she was a constable at the time, spoke to her on the 20th, she gave one version. Then she made a statement to Captain Sawyer, a so-called confession, on the 15th of March. Yes, she implicated herself, but that was not the full disclosure. Then she appears in court as an accused. She's legally represented. In that time, the legal representative also represents Mr. Apollos. She wants to come clean. He withdraws. They appoint a new legal representative for her, Advocate van Tonder, whereafter the discussion takes place. A statement is then prepared after various to and fro and consultations, checked with her legal representative, and that becomes a so-called tool for statement. Further disclosure. So there are those three different statements, whether they're different versions, that's another issue. Then she comes in court and she has a difficult time. So from the outset, she was not a perfect witness. But does it mean that if she was dishonest at a particular stage, that I should disregard everything she's saying? Because it is trite. The fact that you pronounce a falsity on one aspect doesn't mean that the totality of what you say is false. The test is that one must look at credibility, but also reliability. And where I apply the cautionary rule, there's no hard and fast rule. It becomes a common sense approach. And I said at the outset, I'm not going to quote all the authorities. I was referred to them, I've taken them into account. It's my understanding of how I need to approach it, and I will do that. So the way it should be done, to my mind, is to see whether there are independent corroboration for aspects in the evidence, if not the totality, where I can find that warranty of reliability. I have asked the prosecutors, when they had to prepare the heads of argument, to give me a mind map. Now let me pause to say, when I deal with her evidence and the mind map, it will also answer my decision, particularly insofar as it relates to Ms. Smith on the application for a discharge. Because Mr. Van Ryn's application was still born. As just before that, I had admitted his statement, where he implicated himself with admissions. So I will not deal with the reasons for the 174 separate. Let us go there. So in argument we went through points that I indicated I was going to draw lines. That's the talking at the house. There she's corroborated by Mr. Thomas in his statement. So that's the plan. Insofar as the amount of money is concerned, she's corroborated by Mr. Apollos and Mr. Van Ryn. Also corroborated by Mr. Coetzee. as to the argument that ensued on that day, confirmed by Mr. Apollos to Captain Lombard and Ms. Sosa, places it right there. Then, on what happened on the 19th and her presence there, both Mr. Apollos and Mr. Van Rijn, the microwave, and so on. Even then, they had to go and collect the money later. The fact that they smoked water mandrax in the evidence of Captain Colonel Morris, Mr. Van Rijn confirms it in a social media video that was made. The visit to her house on the night of the 19th, where Ayanda got upset. This is confirmed by Gongota and Kobese, totally separate from her. She made mention of that Joshlin was sold. Miss Smith, she says, spoke to her on the 23rd. No counter evidence to that. This whole issue of us talking about the Sangoma, Mr. Van Rijn was the one that came up with that at another stage. I can point at a number of issues, and it's not exhaustive, because my view is to look at it differently. We refer to the elements in what the state need to prove on human trafficking charge. The difference between Ms. Lombard and Mr. Van Rijn and Mr. Apollos relate to the means. She confirms they corroborate her on the plan. At least Mr. Apollos corroborates her on the plan. But both Mr. Apollos and Van Rijn speaks about the execution of the plan of disposing of Joshlin like a commodity on the 19th. That was the plan on the 18th, according to her. And we know as a matter of fact that Joshlin been pursued. Read all of that in, and then I'm going to turn to all the circumstantial evidence and the conduct of the parties and the fact that no evidence was placed. before the court for the defense. So when one analyzes the evidence of Ms. Lombard that was available at the end of the state's case, no credibility findings have been made yet, were evidence of corroboration, because the statements of Mr. Apollos and Mr. Van Rijn were not admissible against Ms. Smith, but they were admissible against themselves. This evidence of record, and if it corroborates the state's evidence, that implicates Ms. Smith. You can only strengthen the state's case on that evidence. And that was the reason why I refused it, because there was evidence before the court on which a reasonable court could convict. So the following findings are made insofar as the witnesses are concerned. None of the evidence was disputed. They then became proven facts. Insofar as Mr. Coetzee is concerned, I accept this evidence for the reasons I've given, having regard to cautionary rule as well. Insofar as Ms. Lombard is concerned, I find sufficient corroboration for the reliability of Ms. Lombard from other evidence and the circumstantial evidence, and that is the discussion of the planning for turning Joshlin into a commodity and selling it. It's a matter of fact that she went missing. She indicated that all three, the now accused, were party to this pact with her. She's confirmed in that regard by Mr. Apollos and Mr. Van Rijn. They support her evidence in that regard. Over and above that evidence, now read with Mr. Coetzee's evidence, with all the other pieces of the circumstantial evidence at play. And most of it, viewed independently and individually, might not seem significant. Because when one evaluates circumstantial evidence, you look at the evidence in totality. And it is so that all these small little pieces on the Swanepoel's example will complete the puzzle. It might also be seen as the little tiles in a mosaic from which you draw inferences. But as discussed in our cases, reported cases, like the ball of feathers that becomes like a millstone around the neck of somebody, it weighs you down. So let's look at the circumstantial evidence. 2018, Joshlin is a baby. Andrews wants to adopt. Build up a relationship between the two families. Parents does not want to agree. The 18th of February 2024, Mr. Paul says he was told by Ms. Smith the reason for selling Joshlin was because of Ms. Andrews doesn't want to stop trying to adopt Joshlin. Circumstantial evidence in that regard, so that the entire becomes private. Turning to Ms. Andrews, Ms. Andrews describes the conduct of Ms. Smith because she knows her, and she tells us how Ms. Smith behaved herself after Joshlin's disappearance. Whilst we're there, let's deal with her conduct. She's inconsistent as to why Joshlin didn't go to school that day. The timeline doesn't make sense. She comes home at 5 or 4:45. On the one version, she was aware that Joshlin was not at home at lunchtime. And why not go look for the child? Then you do. But you find it more appropriate to go charge your phone instead of looking for the child. Then you tell everybody the child may be famous. Then you go jive and dance Saturday on the 3rd of March. And there are many more. This is not the conduct of somebody that's unaware of what happened to the child. They go to sleep that night. I want to say stepfather and mother. Next evening you sleep like a baby. And can you see this house? And so it goes on. Similarly, Mr. Wallace, Joshlin was left in his care. Also, inconsistent versions. Hiding Mr. Van Rijn away, not mentioning Mr. Van Rijn being there, does not partake in the search. He's been told by Ms. Smith, store the tongue, show some emotion. It's uncontested. Why is it necessary? So what I have is that the conduct of particularly Mr. Paulus and Ms. Smith is not that of a concerned parent. And why not? To my mind, the only inference is because you knew. And that supports in itself Ms. Lombard and coming from Mr. Paulus as well. It's not the end of the case. Because all of that was before the court that I've just summarized at the end of the state's case. I confirmed with all three the persons. They chose to remain silent. You have the right to remain silent. As the Constitutional Court pointed out in State versus Busek, it's not absolute. There comes a time where the evidence is such that it calls out for an answer. And yes, you may still exercise precise, you're right, but it has this. Because the court can draw the inference. And the inference I thought is, why not come answer? If you have the evidence, why not come and tell me why? But your conduct was such from day one, not of the job, from the 19th of February last year. There's no real interest. You don't do research. You don't do well. Common sense nonsense to do. So let's turn to the whether on these facts I can make a factual finding of what happened to Joshlin. Was she delivered to the white photo? Was she delivered to Macarina's house? As from Mr. Thomas and Mr. Frank. Because of the different versions that Miss Lombard gave, I can't find a warranted reliability for white photo. So that's not proof beyond a reasonable doubt on that score, because of the cautionary rule. But is it necessary to find how the means how Joshlin was delivered? I've already made a finding as to how the law should be interpreted by saying it's not necessary, but it can be inferred because you have the plan, you have the purpose, you commodify, hand over, and it's a matter of fact. Does that satisfy the requirements of the charge? So, on the main count, I have already found that on the evidence before me, Joshlin was exchanged. The fact is that her freedom of movement and liberty was inhibited. Now that in itself are the main elements of the act of kidnapping. Kidnapping is mentioned as one of the means in subsection G of section 4.1, but also the evidence is from all sources. There were payments, or at least the promise of payments. Also, if one looks at the overriding subsection J of the Act, it refers to the purpose that include slavery or practices similar to slavery. And the definition section of the Act defines slavery as reducing a person by any means to a state of submitting to the control of another person, as if that person, that other person, were the owner of that person. So by treating a human being, in this case a child, as a commodity that can be sold, it falls within that definition. I've already commented by looking at what the Act is for kidnapping, when I determined whether it falls under the subsection 441 contravention. Clearly that act of depriving Joshlin of freedom of movement and liberty, to the extent that the whereabouts is still unknown, is unlawful. So that will satisfy the elements of the offence on count 2. Now before I make a pronouncement, I also have to deal with the indemnity of Ms. Lombard. I have decided not to deal with that application or my determination of it now. They will clearly be clear from what I've said so far that there will be another stage in this case. And one doesn't know what more evidence might be presented at that stage that might influence that decision. Furthermore, in the event that I act out on that question after all the evidence in the case has been laid, I might consider wanting to grant Ms. Lombard's legal representative to address me on the issue before final determination is made. But the primary reason is that I foresee a possibility that the evidence might still be there in the next phase of this case that might impact that decision. So for the reasons that I have stated, I'm of the view that the state succeeded in proving the guilt of Mr. Thomas, Mr. Van Rijn, and Ms. Smith on the main count in count 1 and on count 2, so the following order is issued. You may remain seated. On count 1, you are guilty of a contravention of section 4 of the Act, read with the other legislation on trafficking in persons in relation to Joshlin Smith. On count 2, you are also convicted of kidnapping. Can I just ask the public, please just bear with us. I know that's emotional, and I understand the expression of your emotions. let us complete our process that we need to do for now. Then I'm going to adjourn. Then you can express your emotions as you wish.
At
60 minutes.
my old man, he's number one to do both as previous conviction, but also allowed me to leave him out.
Certainly.
As for keys number one,
Mr. Policy must listen.
on the 22nd of October 2020, the conviction of theft committed on the 22nd of August 2020, the sentence imposed was a fine of 1,000 rand and 10,000 for 10 months imprisonment, which was wholly suspended for 3 years on condition not again convicted of theft or theft. And there was also a declaration that he is unfit to possess a firearm. I will raise the only conviction against his firearm.
Mr. Paulus, do you admit the previous conviction? You will be given the form to sign. And I'm not sure whether you have a fingerprint pad here. You can do the fingerprint later, Warren Doctors. Just leave it there, so.
I will be highlighting proceed with Simon Rain. On the 3rd of October 2014, convicted of 2 counts of robbery, which was committed on the 17th of March 2014. The 2 counts were taken together for purposes of sentence and 24 months imprisonment, which was wholly suspended for a period of 3 years, on condition that it not again convicted of robbery or serious robbery in the period. And there was 12 months correctional supervision imposed, and he was also declared unfit to possess firearms. The next conviction is on the 17th of January 2016, also for robbery, committed on the 23rd of October 2016, and then he was sentenced for 2 years imprisonment. And then the next previous conviction is on the 28th of March 2018. That was a confirmation of section 4B of Act 140 of 1992, positional arrest of drugs, committed on the 26th of March 2018. The fine is 105 days imprisonment. I will say the next one is on the 9th of December 2020, convicted of housebreaking, intent to steal and theft, committed on the 4th of October 2020. He was sentenced to 24 months imprisonment. On the 11th of June 2021, released on parole supervision, which was supposed to be until the 8th of December 2022. There was, however, an extra endorsement where he was readmitted. The endorsement date was the 28th of October 2021 to serve the remaining portion of the sentence, 407 days imprisonment due to a violation of the parole supervision conditions. Those are the previous conditions of
Mr. Van Rijn, do you amend your previous submissions? Thank you. So whilst the administrative tasks have been performed by the constable, we now need to plan. So I'll tell you what my prima facie view is. We should maybe postpone the matter to a holding date, which will be a date, say, not this coming week, the week thereafter in Cape Town. I will deal with it early in the morning. And by that date, we will then determine whether you're going to be the evidence in aggravation. I suspect so. Whether the defense wants to call any witnesses in mitigation. Then we'll know how many witnesses we need to call. I hope nobody's going to ask me for correctional supervision report because it's not applicable. No, I'm talking about the defense already. I'm talking about correctional supervision, but we also don't know whether there are any other assessments that we know. So once we know that, we will have an idea how long it will take to compile everything, but also how long we will need for the sentencing proceedings. And then I would want to come back here, because I think it's just fair that we do it here. But all the prep work we can do whilst we in Cape Town will also give me the opportunity to, I thought I might still have to go to the office in town today. I was supposed to be in Cape Town today, in the office. But I'll see what I can arrange. So that's just my idea. How do you feel about that from the state side?
That sounds good. We say that we need some evidence, at least we can accept what we can create.
If the defense, if I might just ask, if the defense could perhaps indicate that they want to...
I'll hear now. Mr. Hansen.
Obviously, the defense we are given one need to consult with you. We need to the arrangement proposed to Lordship for a date in Cape Town. We obviously need to consult with the given one and then take instructions as far as the procedure further.
Will you be able to, next week Friday, will you be able to advise me by next week Friday? In other words, I can postpone the matter till Friday next week, which is the 9th of May. I doubt I have appeals, but we will have a courtroom available, so I can do it in my courtrooms there. That's just for everybody to report back. This is what we want to do, so that we can start planning.
In agreement, I'll be in agreement with that for the 9th, yes, my lord. Yes, I'm in agreement, my lord.
Morning, my lord. I'm Gabai on behalf of Mr. Van Rijn. I would concur or concede with my learned colleague's submissions that the matter be heard on the 9th. I have to consult with my client, and I will, on that day, explain to court what are my instructions.
So it's now, it's 10 to 1. I'm going to they must be transported to Paul's. It's going to be difficult now if I issue the order now for Paul's. So I'm inclined to do 2 warrants, 2 detention warrants. to authorize both places. And as I say, at this place and or that place, so that maybe tonight they can be held closer so that they don't have to take them out 27 on a Friday in the middle of a long weekend. Otherwise, the police will only reach Paulsmoor when tonight. And they're going to hit the peak hour traffic on their way to Kai. So I'll hear from Warren if I say Malmesbury, and then during the course of the week they can make arrangements for them to be transferred. And it will be Langebaan for Miss Smith for tonight. It'll just make it easier, because I can foresee problems if it's too late. Also, we're not sure what time they're going to leave from here now to where they need to go, because there's a lot of admin to be done. I'm also aware that, because we made the arrangements the other day, that their parents might be here. I'm not going to make an order. It's not my place. But often what I do is, if I convict somebody, and if it's possible, I tell the board orderlies, if it's within your powers, I won't have a problem if you at least have their family speak to them before you take them away. But I'm not going to make an order because I don't know what the arrangements are. So the following is going to happen. Mr. Van Rijn, Mr. Apollos are going to do your warrant due, so it will be Malmesbury, Paulsmoor. Ms. Smith, I'm going to do you Langebaan, Paulsmoor. You will be appearing at the High Court in Cape Town on Friday. All that will happen there is I will be informed how we're going to do the process further. And it will depend on availability of witnesses, reports, and so on. And once I have that and we determine a date, we postpone the matter back here for a day or two. It won't take longer than 3 days, I think, to come and finalize the matter, where I will then have to impose sentence. I want you to give your legal representatives instructions as to what you want to do. Because remember, there is a prescribed sentence of life imprisonment on count 1. Just remember that. So that you don't sit back and it's your choice. But so that I have everything before me, and I know the state is going to argue for life imprisonment. So, just give your instructions. Members of the public, can you just remain calm now? I'm going to adjourn. Then give the police an opportunity to take Mr. Apollos Van Rijn and Ms. Smith out of the courtroom to the holding area. And then you can quietly leave, or if them on a clap, later, whatever, that's your business. Right? I'm not going to stop you, but let's give them the opportunity to do their work. And then we leave orderly. Remember, we have a big number of people in this hall. Let's leave orderly and thank you for coming. The court legend.
All right, those breaking news coming out of the Western Cape High Court sitting in Saldanha. Judge Nathan Erasmus handing down a guilty verdict for the 3 accused in the Joshlin Smith trial. Both Kelly Smith, her boyfriend Jacqueline Apollos, and their friend Stephen van Rijn have been charged and found guilty of contravention of Section 4.1 of the Act, which is for human trafficking as well as for kidnapping. The judge in this matter saying that the conduct of Ms. Smith was not of a concerned parent, and that he infers that it is because she already knew what had happened to Kelly Smith. The judge had spoken about that Joshlin was indeed exchanged, her freedom of movement was inhibited, and the evidence is that there was payments or a promise thereof. You're seeing scenes there coming out of that court sitting, very happy citizens and community members of Saldanha Bay for this judgment that has been handed down to these 3. The judge saying that now, going forward, they need to be transported to the Pollsmoor prison. But for now, the first 2 accused, Van Rijn and Apollos, will be held at Malmesbury prison, and Smith will be held at the Langebaan prison, and later in the week, they will then be transferred to Pollsmoor. He said going forward, they will appear on the 9th of May, on Friday next week, where the judge will give a way forward with regards to what's going to happen with regards to the matter as well as witnesses. Then the matter will be brought back to Saldanha Bay for finalization as well as for that final sentencing. He did also remind them that the count 1, which is contravention of Section 4, could have a life imprisonment. Let's now take you to Valen Kirtley, who is outside court. Let's get a sense of what is happening there. Valen, it seems as though very happy community members coming out of that court sitting.
Yes, of course. How are you feeling?
I'm full of emotions at this moment. I am exhausted. It has been a long journey for me, especially for me and a lot of people from Cape Town, people from TikTok, staying up late at night. It's very overwhelming at this point in time. But I mean, I think we got what we wanted, and that was the guilty part. That's one part through now. Now we're just waiting for the sentence.
Is it a little bit of an empty victory because we still don't know where Joshlin is?
Yeah, that's why I'm saying a lot of emotions right now, because despite the guilty that they were found, we still don't have Joshlin, and it's like taking a bitter pill right now. So we're walking away here empty, still with no answers.
You mentioned that you came from Cape Town. Can you tell us what your relationship is with this case and with Joshlin Smith?
I have been on the case since it started. So I've been in Saldanha from the very beginning of the case, and today I walk away shattered because we never got her. We didn't get her. She's still not here.
Thank you very much. And that is some of the sentiment, Kadlecho, that is coming through from the people who have been sitting in the gallery. It was a full house today. Many coming out saying justice for Joshlin, chanting justice for Joshlin. Ma'am, do you feel that today justice has been done?
Justice has been done, and there is more to come. The only sad thing is that we still don't know where Joshlin is.
It's been a long morning. How are you feeling at the moment?
It's been a long year. I'm happy, but like I said, we still haven't found her. So, yeah.
What is your connection to Joshlin and to this case?
Absolutely no connection. I've been following the case since Joshlin has gone missing, and I'm here today just to see what happened, if they were going to be found guilty or not.
Thank you very much. So those are a couple of the sentiments that are coming out from the courthouse at the moment. I'm going to try and see if we can chat to a few more people as they've been sitting for the morning from the time that Judge Nathan Erasmus started delivering his judgment. Can I chat to you ladies? How are you feeling at the moment?
We're very glad. We're very glad for Joshlin. We're glad she's guilty.
Can you take us through that moment when the judge actually said on count 1 and on count 2 we find you guilty?
It was very emotional. It was very emotional just to think and wonder where the child really is. It was very much emotional when the judge was speaking.
Are you from Saldanha, or what's your connection to the case?
From Cape Town. I'm watching it on YouTube, and my friend decided we're coming through to Saldanha today. We're from Cape Town.
What about this case has actually captured your attention that you thought it was appropriate to come all the way here to Saldanha, a 2-hour drive from the city of Cape Town?
As a mother, I feel it. As a mother, it really touched me. That's the reason why I come through to come see the court case.
All right, those are just a couple of, thank you so much for chatting to us on Newsroom Africa. Nasibi, those are just a couple of the sentiments coming from the people outside. They quickly made their way outside of the hall and are now walking. There is this magnificent portfolio, artistic depiction of Joshlin in happier times. But let's go inside the court to Nasibi.
I'm not there. Where is Joshlin? Because in my opinion, there's someone, you know what I mean? I get it.
And then just the last question from me. Your son isn't in court today, Joshlin's daddy. Have you relayed the message to him yet? How is he doing? What is he feeling?
I cannot say because he's not the person who spoke. And the reason he's not here is because of Rochelle. And he must take care of her in Sasa stuff. That's all.
Giving a reaction to that judgment that Judge Erasmus has just given. Let's go back to Valen as she continues to get some reaction from community members in Saldanha Bay.
I tell you, I think it's more excitement, and I think everyone's just happy that justice has prevailed. Like, although it's been postponed again, but we know what's going to happen, and all we want to know now is Kelly actually going to say where Joshlin is now? That's all we want to know where our child is. So,
can you tell me what your connection is with the case?
So I have actually just been following it. I've been watching it, but these Cape Townians came and fetched me last night, 7 o'clock at my house, and they made me sit here all night with him. And so yeah, but I also try to help with the search and actively look for her. But yeah, the advertisement. But I've been following it like the Oscar Pistorius case to be totally. It's like I haven't missed one court case.
So you've been here from midnight, staying overnight just to make sure that you got a spot in the courthouse?
We got here at 7 o'clock last night, yes. And we haven't slept. So this is a happy moment.
Thank you very much, and safe travels onward. Let's see if we can chat to a couple of other people as they come through the courthouse. Many of them with t-shirts with the face of Joshlin Smith on it, and some with badges with Joshlin Smith. Sir, how are you feeling at this moment?
I feel happy about the outcome, but we're just waiting for the sentencing. That's all we're going to do now. And it's very sad. If they can find us where Joshlin is, where the child is, I'll be very happy. Because we're all looking for the child. I'm here 33 years in Saldanha now, and we've all been searching and looking for Joshlin.
For the last 15 months, the whole community has continued looking for her every single day?
And we start continuing looking for her.
And Nasibi, that's the kind of sentiment and the reason why you see these emotions outside of court, because Joshlin was loved by this community. That's something that Judge Nathan Erasmus also said, that it takes a village to raise a child, and in this community she was loved, but she was also unsafe in her home by the one person that needed to love her the most, being her mother. Nasibi, let's go inside court, where I believe you are also standing by with some immediate reaction.
Well, that is indeed true. We are still inside court minutes after the judgment was handed by Judge Nathan Erasmus, finding the 3 accused of kidnapping and human trafficking guilty. We saw how emotional Kelly Smith was when that judgment was handed. However, building up to that very anticipated moment by a very packed gallery, Judge Erasmus took the court through the evidence that was presented inside the Western Cape High Court, and the timelines and the corroboration in the various testimonies that we heard, particularly of the key state witness Laurentia Lombard, including evangelist Stephen Kutsia, who was the one that detailed to court and testified that he was made aware of the plan to sell Joshlin in August of 2023, indicating that in a couple of months' time, between January and February, they will be all gone, and that she intended to sell her 3 children due to the family circumstances. We also heard Kelly's mother speaking for the first time to the media, indicating to us that basically what she wants is her grandchild and Joshlin. And Judge Nathan Erasmus, on numerous occasions building up to the judgment, he mentioned that we are dealing with a human trafficking and kidnapping a case or trial of a child that remains missing. And we heard during the testimonies of this 9-week-long trial by the investigating officer that the missing person inquiry into Joshlin remains open, as they are yet to find her. We also spoke to the paternal grandmother of Joshlin, Rita Yon, who said that at some point she visited Kelly in Paulsville trying to ascertain some sort of information and tap into her motherly instinct and see whether or not she'll be able to at some point open up and reveal where the child is. So that was the outcomes of the court today. A very, very packed gallery, a number of people here keen and vested to hear what Judge Erasmus will say, and many cheering, indicating that having the conversations that we had outside, that perhaps justice did prevail for those that were here, very, very keen in wanting to hear what the outcomes and the verdict will be in regarding the fate of the 3 accused who will be appearing next week Friday at the Western Cape High Court in Cape Town, where Judge Erasmus will be addressed by counsel as to how they move forward regarding this particular matter, as we're yet to touch on the element of sentencing.
All right, Nasipi Samek bringing us that reaction. We still have Valen Kirtley, who's outside the court with very emotional community members now that Judge Erasmus has handed down that judgment.
Ons moenie nou ons nie kom swak raak nie. Kom ons vra die Here vir ons sterkte maak dat ons 'n kind kan kry.
That justice is so, but where's the child, man? Say where's Joshlin? We want Joshlin, man. Just give us Joshlin. Give us Joshlin.
These are the raw emotions that are coming through. There's just no other way to describe it. As much as there is a guilty sentence of kidnapping and trafficking, this is the call and this is the cry of the community.
Say with Joshlin. You can't follow all year, and you follow all TikToks, and you follow everywhere, and nobody can say where's she body. Say where's the child, man.
But Shaven, tell us, how do you feel about at least the conviction?
To me, it's all good. I'm happy, very happy about it. Yes, the year, man. They've been convicted, man. But at the end of the day, that doesn't give us the answer where our child is, man. Tell us where's our child.
These are just some of the emotions from women who must be mothers, aunts themselves. But what does the paternal grandmother have to say? Nasipi is inside with her.
Well, Valen, fortunately for us, we do have the paternal grandmother of Joshlin, who is Rita Yon, who has been part of this investigation, following it through from its inception when Joshlin disappeared on the 19th. How are you feeling?
I'm feeling happy for the outcomes of Judge Erasmus. I'm feeling happy for the outcomes, but still missing Joshlin. Joshlin is still missing.
Talk to us about that pain that you're feeling, missing your granddaughter, that she remains or that remains missing.
Yes, it feels not nice to didn't know where is she, what she eat, what she drink, or where she sleep, and how the people here ever treat her.
How is the family coping with Joshlin's disappearance, particularly her younger sister?
She didn't know about Joshlin's disappearance, but she is still with her father and my sister, but how older she is going to be, they're gonna tell her. But she mentioned Joshlin's name every second.
And Rita, we know that you visited Kelly when she was arrested and went to Paulsmoor to try and get her to speak. Talk to us about that very emotional visit.
Yeah, I go to Paulsmoor. I ask for Kelly. Kelly asked me. She heard Joshlin is founded. I say no, Joshlin is not founded. That's why I'm here, to know where is Joshlin. She said she didn't know where is Joshlin. I said, Kelly, you can't tell me you didn't know where is Joshlin, because why, you are the one who's going to show Joshlin for the people. You are the one who's going to take the deal with Joshlin. You're the one who get in the car with Joshlin. So you must tell me, where is Joshlin? She don't know.
However, today she was quite emotional when Judge Erasmus found them guilty.
She didn't expect something like that. She was still thinking she's famous.
Rita, thank you so much for your time. That is Rita Yon, the paternal grandmother of Joshlin. The father of Joshlin attended court proceedings as well, religiously, as we do know that he is working in a different province. We now hear from Rita that the youngest or the sibling to Joshlin is now in the Northern Cape with her father. However, the family now, with the guilty verdict, as Rita is saying that they're excited, they still need to deal with the fact that Joshlin remains missing more than a year later. And as Rita says it, she has not received that information that she was looking for from Kelly when she visited her from prison as to where Joshlin is. And she now, lives with the fact that, or rather asking herself unanswered questions as to where her granddaughter is. Is she eating? Is she warm? Is she being loved wherever she is? So that is currently what is playing out inside the Western Cape High Court. And just not too long from now, we will be speaking to the Provincial Commissioner of the Western Cape, Lieutenant General Pategile, regarding the investigation and the work that was done by the police, and where to from here as the missing person inquiry remains open.
All right, Nasipi Sami, certainly a bit of